Hello, I'm Susan Schoenfeld, Senior Legal Editor for BLR's Human Resources and Employment Law publications. I'm here today to talk about medical certification under the Family and Medical Leave Act, or FMLA, which is the topic of many tough questions we receive from HR managers through our Ask the Expert service. We recently received this question from a frustrated employer. I have an employee who is off work due to a workers' compensation injury. The employee refuses to get FMLA medical certification. Is there anything I can do? He goes on to ask, when his 12 weeks are up, would we be able to terminate this employee? Or, worse yet, could he say he didn't use any FMLA leave? Well, first, remember that under FMLA, the employee has to provide the requested medical certification to the employer within 15 calendar days after the employer's request. This is true unless the employee can prove that it was not practicable under the particular circumstances to provide the medical certification, despite the employee's diligent good faith efforts. Or, in some cases, if the employer allows more than 15 calendar days to return the requested medical certification. Well, in this case, the employee is definitely not making those good faith efforts. In fact, he's making no effort at all. An employee has an obligation to not only return medical certification, but also to respond to an employer's questions designed to determine whether an absence is potentially FMLA qualifying. If an employee fails to respond to an employer's reasonable inquiries regarding the leave request, the employer may deny FMLA protection if the employer is unable to determine whether or not the leave is FMLA qualifying. So in this situation, the employee is already on leave for workers' compensation, so this wouldn't work. However, the use of denying or delaying FMLA leave is very useful in situations where the employee is not otherwise eligible for leave. So in this situation, if the employee refuses to return FMLA paperwork, the employer may designate the leave as FMLA leave based on information it has regarding the workers' compensation injury, and assuming that that information will satisfy the FMLA's tests for a serious health condition. At the end of the 12 weeks of FMLA, the employer has to consider whether the employee is entitled to additional leave under ADA or state disability law as a reasonable accommodation, if that's applicable. But if the employer determines that the employee is not eligible for additional leave at the end of his or her FMLA leave, the employer should first consult with employment counsel, given the interplay of workers' compensation, FMLA, and ADA in this situation. It makes it a particularly prickly situation for termination. Now remember, it's the employer who's responsible for designating leave as FMLA qualifying and for giving notice of the designation to the employee. It's not up to the employee to decide whether leave should be designated as FMLA leave, try as they might. And when the employer has enough information to determine whether the leave is being taken for an FMLA qualifying reason, for example, in this case, after receiving information regarding the workers' compensation injury, the employer can, and in fact must, notify the employee whether the leave will be designated and will be counted as FMLA leave. The employer has 5 business days to do this, absent any extenuating circumstances. In a previous video in this series of Q&As on FMLA medical certification, we addressed the question of whether obtaining medical certification is always necessary for leave. In our next video, we'll address whether an employer can require an employee who takes intermittent leave to care for a child's serious health condition to provide a note from the child's physician for each and every missed day. HR.blr.com's Ask the Expert service is an exclusive benefit for our subscribers. And to learn more about becoming a subscriber, please visit hr.blr.com. Thank you.